Good evening, everybody. Jonathan Ginsberg here. Hope you are all doing well. Today is August 13th, Wednesday, my normal Wednesday evening live stream. Hope everybody's doing well. And let's see what's going on today. Just got some nice comments. One thing I did want to mention, I put this at the bottom of the screen. I have I started an Instagram channel for Ginsberg Law Offices, and I'm trying to build it up a little bit. So if you're so inclined, check it out, instagram.com/Ginsberg Law Offices, and a subscription would be, or if you would subscribe, that would be very, very helpful. That is something that I'm trying to, just another channel. And I figured out how to put not just the short videos on there, but longer videos as well. So I've got a little bit different content than I have on my YouTube channel. I can stream the live stream to Instagram. The problem is it only lets me go for an hour. So I'm still trying to figure out what to do about that. But bottom line is if you're interested in some just a little different content, please give it a look and subscribe if you would not mind. I would appreciate that very much. So let us jump right into the questions. And SA says, had lumbar radiculopathy, which basically means low back pain with radiating pain into the legs. Afraid of recommended surgery. And obviously with lumbar problems, it's either going to be a laminectomy or possibly a fusion, pretty intense surgeries. Failed physical therapy, epidurals, medial branch blocks earlier this year. MRI from January of 25 reveals severe foraminal stenosis, a large disc bulge, possible L5 contact. Went to a new pain clinic. They want to do PT, a new lumbar MRI. Expensive, wanted to try things not already tried. Advice, old doctor would not have redone things like this. Old doctor means ortho from early 2025. Pain clinic recommendations are from the PA, who only has my January 25 MRI reports and no records from previous orthos, but knows I failed PT. And let's see what else we got here. There's also a lateral recess and foraminal stenosis. So what we've got, SA has went to the doctor, had a fairly recent MRI that shows some pretty significant problems. Went to a different clinic and basically went to her doctor said his or her doctor said you need surgery. SA is very concerned about undergoing surgery. And I will tell you, surgery, especially fusions, and I don't know if that's what the case is here. They sometimes don't work they may work initially, but they may not work for a long period of time. What happens is people develop what they call adjacent segment disease. And what that basically means is that the levels above or below the fusion become stressed because now you have a fusion. There's no mobility in that part. So the levels above become more stressed and it can cause problems there. Also, fusions can fail. Scar tissue can form. A lot of things can happen. So it's not at all unusual for someone to decide they don't really want to go through back surgery. They can work sometimes they don't. Social Security will not hold it against you if you choose not to undergo a back surgery, by the way. So what's happened here is SA went to another doctor, and the other doctor is saying, well, even though you just had an MRI, even though I know you failed physical therapy and epidurals, we want to do it all over again. And unfortunately, that's not that uncommon. You go to a different doctor and they want to try, their version of physical therapy. They want to try their version of, the conservative treatment. They want an MRI. Sometimes it's about money. They want to get, the new doctor wants the physical therapy clinic associated with their practice to get some more business. They want to rule out, especially if it's going to be a pain management doctor who's going to be prescribing narcotic pain medications, they have to prove they personally went through an analysis of your case to make sure that, pain management is the best solution for you. And to be fair, doctors nowadays, if they're prescribing narcotic pain medications, they're watched. The government watches what they do. And I think if a doctor was to prescribe pain medications without putting you through at least some, conservative treatment and non-invasive type of treatment, that could be the reason why they're doing that. It could be money, it could be that sort of reason. But that is probably the more common reaction than not. Now, obviously you could talk to them and say, here's an MRI from 6 months ago. But they may have their own policies. So, what I would tell you is ask them why. Why do you feel that you need to do all this stuff over again when I just had it? And again, it may simply be because they've got to go through that process to satisfy, the powers that be that's legitimate to prescribe pain management, or it could be some other reason. But that's what's going on in my guess. And I suspect that you're going to have to go through all that, duplication, as it were, because that's just the way they are going to do it. So that's what I would tell you. But that's my thought on that. All right. And by the way, these are reading glasses. I'm trying out some new. I normally wear regular glasses. Just actually they're progressive or sort of bifocal kind of glasses. I normally wear them, but I went out tonight to play some tennis. We got about 40, maybe 30 minutes in before it started raining. But I had just gone to the eye doctor a couple of days ago, and they gave me a new pair of contacts to try, a different brand. So I'm just wearing those. Because I want to see how long I can wear them before they become uncomfortable. So believe it or not, even though I've got contact lenses, I can't see to read, so I got to wear reading glasses. So you'll see me taking the glasses on and off. That's why I'm doing that. When you get old like me, that's what happens. You can't see with glasses, you can't see without them. All right, Catherine says, I have MS, had a lawyer, I'm assuming multiple sclerosis. I got SSI with Medicaid, 57 GAL. I'm not sure if you're saying you're a 57-year-old female, confirmed MS at 26. So you've been on SSI for a long time. And again, SSI is not the same as SSDI. So I know people sometimes confuse the two, but it appears that if you've had MS since age 26 and now you are 57, obviously you've had it for a long time. And if you're on SSI with Medicaid, when SSI does go with Medicaid, then, it's pretty unlikely you're going to be undergoing any kind of review. And, obviously being on SSI that long, as it limits what you can do in terms of assets or, other people in the family, spouses, things like that, because, if you have household income, it would be deemed to you. So it really limits you. I think in a lot of ways, SSI keeps people kind of under the gun and financially unstable because of the very, very outdated income and resource limits. But I'm glad you haven't had problems with Social Security trying to review you. And by the way, people sometimes will ask me, I've been on SSI, can I get on SSDI? Unfortunately, it doesn't work that way because SSDI is looking at your earnings record the last 10 years. So if you've been on SSI for 20 years, you won't have any earnings records. Most likely you're probably not working. So there's no way to get into SSDI. Theoretically you could become a disabled adult child, but I think if you're 57, that's probably long gone anyway. So, but yeah, I appreciate you tuning in, and I'm glad that you are still getting it. Okay, let's see what else we got here. P. Brown. Thank you for your videos. Very helpful. You're welcome. P. Brown, if a 59-year-old office worker with a 15-year work history, the same job develops arthritis in the fingers and thumbs, does that meet a listing? Probably not. If you look at the orthopedic listing, and that's listing 1, if you go to my website, meetalisting.com, and you link to the listings, you'll see listing 1 covers orthopedic listing. You're going to need more than arthritis in your fingers. I think that, generally speaking, the orthopedic listings require a, very, very high level of damage. Typically, for example, they talk about, lack of use of one of your extremities, your upper extremity or lower extremities, not being able to walk, non-healed fractures. I mean, it's they've made it more and more difficult because orthopedic issues are the main reason why people cannot work. That's what they're claiming. So if you're 59 and you can't use your hands, and again, you didn't say if that's both hands or one hand, um, you know, probably a better argument to look at would be the grid rules. And if you look at gridrules.net, that's my website for that, um, because the grid rules talk about lifting. And if you are age 59, then you can look at the light grid rules, the 202 section. If you look at the grid rules for light, if in other words, that your functional capacity is limited to light, um, basically a light functional capacity or light residual functional capacity means standing and walking for 6 out of 8 hours in a day, lifting 10 pounds frequently, 20 pounds on occasion. So what the grid rule says is even if you could do that, even if you could lift 20 pounds on occasion being up to a third of the day, you are still disabled. So if you have severe arthritis in both hands and you can't lift 20 pounds even occasionally, you would have an argument that the grid rule applies. Now you have to also show that you have no transferable skills, but the grid rules are a really, really powerful tool to make it easier. It changes the definition of a disability, makes it a lot easier for people, who are over 55 to win. So that may be something to look at. Now, again, you didn't say if it's in both hands and thumbs and how much it limits you, but if it is both hands and thumbs and it does limit your lifting, and you, again, that's, how do you prove that? You could obviously, testify that you tried to lift, a 15-pound bag of potatoes and you couldn't do it, or you can get a formal functional capacity evaluation with a physical therapist and get, documentation that says you can't lift 20 pounds even occasionally or 10 pounds frequently. But if you can prove that and it's bilateral, I think you've got an argument. If it's only in one hand, even the dominant hand, that's a little more troublesome because I think that, if you can say I can't lift 20 pounds occasionally with my dominant right hand, but what about your non-dominant left hand? And again, it's just a little bit harder to prove in that situation. So, and then of course the other argument you would make would be that so you have the listing argument, which I don't think is going to work real well here, the grid rule argument, which might if it's bilateral, and then you have a functional capacity argument. That's the third argument where you basically say the combined effect of, my lack of use of this hand or both hands, plus medication side effects, plus depression, plus anything else going on, when you put them all together would make me so unreliable that I would miss 1 or 2 days of work per month, or I'd be off task 15% of the day, things like that. So those are the three theories of disability. So, again, you might have the thing that jumped out at me was the grid rule. Anybody who's 55 or over, you want to take a look at that if you've got physical limitations. Now, Eunice Sala is 54, has a herniated disc between L4 and 5, cannot stand, and you said long periods of time. And Eunice, I want to make sure we're clear. You want to stay away from long periods of time. That doesn't mean anything for Social Security. That could be 10 minutes. It could be 3 hours. What is a long period of time? And you can't lift more than 10 pounds. So again, at 54, you could look at the sedentary grids, which basically say that even if you could do sit-down work, and that's standing and walking no more than 2 hours a day, lifting 5 pounds frequently, 10 pounds on occasion. So again, you're not over the, at the sedentary grid, you can lift 10 pounds. So that's going to be an issue there. Standing long periods of time, if you can stand up to 2 hours, it's going to take you out of the grid. What are the chances of winning? I would tell anybody who's 54, if you can wait till 55, it makes life a lot easier. Case in point, I had a hearing today, right at about 11:45 today, and my client is I believe he's 62 now. And he had filed an application. We'd filed it for him. And I'm sorry, he's not 60, he's 57, I think. When we filed it, his onset date was 50. He was 52. Well, what they did was at the administrative level, they approved him as of his 55th birthday. So he's getting money. The problem is our onset date was 52. So basically, he lost out on 3 years of past due benefits. It was about 30 grand. So we talked about it, and I said, let's appeal this because, is it really likely they're going to find, and I'm not going to go into his, just for privacy, but he has some significant medical issues. They're not going to find you not disabled as of 55. Really, the worst that can happen, in my opinion, would be that they're going to find you disabled as of 55. And so we wasted some time, but you're not going to lose anything. And so what ends up happening is he's over 50, he's 57 now. And he was, like I said, between 50 and 55 then, but he has some significant problems. And the judge basically found him limited to sedentary work. And he meets the grid. I think it's 201.12. The judge says he meets the grid. We win. He gets $30,000. So, if you can prove you're limited to sedentary units, then, you have an argument. But I think that, you've got a herniated disc. And again, the details matter. Does it compress the spinal cord? You have what they call nerve root impingement. Is there any sort of radiating pain into your legs? Stand for what is a long period of time? Is it 10, 15 minutes? Is it, 3 hours? I mean, that makes a difference as well. Lifting 10 pounds, like I said, it may be that you could squeeze into the sedentary grid, but my experience has been if you file and you're 54 plus, what they're going to do, because they want to try to save money, is they're going to basically find you disabled at 55 anyway. So my thought would be that's probably where this is headed. A lot of cases, people that are, 54, they move them to 55. If they're 59, they move them to 60 because there's some other rules that apply. So I would say, yeah, wait. If you can keep working, hang in until 55, wait till 55, your chances, given this, go up. And again, we don't know all the details, but if you could wait to 55, that's going to make your case a lot stronger. I think if you try to get it as of 54, there's more than a 50-50 chance that their Social Security, either at the adjudication level or at a hearing level, is going to move you to 55 and approve you then. And again, the risk is, which you have to be careful about, is let's say that you got approved administratively as of your 55th birthday, and you say, no, I want to get that extra year. Well, if you appeal a partially favorable decision, you appeal the approval at age 55, the entire case is now at issue. You get in front of a low approval judge, and what they gave you they're not bound by that. You could get a low approval judge who says, sorry, you're no longer disabled at all, and you got to pay them back. So again, my feeling would be if you could wait to 55, that would probably be better. If you can't, you can't. But all in all, that's I think a stronger argument. And again, happy to answer your question here. Darren Maga, let me actually change this banner here because I'm given instructions to do so by the powers that be. Darren Magaha is 57, a GED, which is essentially a high school education, bad back with an MRI, knee is bone to bone, right foot arthritic, COPD, how will morbid obesity influence my case? Want to make sure everything is ready. I think that morbid, obesity used to be a listed impairment. And it used to be, when I first started doing this, that if you were a certain height and a certain weight, you could meet a listing. It was assumed that a person, let's say, who's 5'6", who's 350 pounds, was disabled because of weight. They got rid of that. So there's no longer an obesity listing. But I think that you've got you said bad back. And again, is it a bulge? Is it a herniation? But you're 57. So when you add all these things together, MRI showing something, either a herniation or a bulge, perhaps some, spinal cord compression. Your knee is bone to bone, which is going to limit you walking. Right foot is arthritic, going to limit you walking. The COPD going to limit your exertional capacity, and you're morbidly obese. I think that says to me grid rule, that the idea that you're going to be able to do light work And GED education suggests there's probably not a lot of transferable skills from what you did. But at 57, even if you could do light work, and again, light work means standing and walking 6 hours a day, lifting 10 pounds frequently, 20 pounds on occasion, I don't see how a person with these limited physical limitations is going to be able to stand and walk 6 hours a day. So in that sense, I think that you've got a grid rule argument. Look at 202, grid 202.06. Let me go ahead and pull the grid up, because I know we talk about this a lot, but let's go ahead and I'm going to pull it up so I can show you. And again, if you go to gridrules.net, and like I said, the grid rules are really helpful because it changes the definition of disability. So if we go to this one here, and again, this is at gridrules.net, if you look at the light, so your capacity is limited to light work, meaning that you can do, under this assumption, you can stand and walk 6 hours a day, you can lift 20 pounds occasion. Even if you can do that, and I don't think you can, even if you can do that, you're disabled. So to take it another step further, the next step up is called medium work. Medium work is lifting up to 50. I think it's 50 pounds. I'm pretty sure that's what it is. So, obviously there's no way a person who's 57 with bone on bone knee, bad back, right foot problems, COPD is going to be able to do medium work, lifting 20 pounds, 25 frequently, 50 occasionally. So I think that, even if you can do light work, which I don't think you could do, if you look at 202.06 says 55 plus, high school grad or more, which GED is, does not provide for direct entry or any transferable skills, you are disabled. So again, if you have a GED, I'm guessing your past work was probably not executive function type of work. Maybe it was semi-skilled, but it's probably not going to give you a lot of transferable skills to sedentary work. In other words, let's say you did warehouse work. There's no sit-down jobs that they're going to be transferable from that. So I think you've got a good argument under 202.06. Again, subject to what the evidence actually shows. But I think that you're smart getting your case in order, but you are, I think, in pretty good shape. That's a case to me that would be a winner. I would take that case. That's a winner in my opinion, assuming the medical says what I think it would say. Okay. Our buddy Rodney is here. Rodney is here most weeks. He's a former client of my firm that we won, interestingly, with a really, really difficult judge. And that same judge, by the way, it's who's got a very, very low approval rate. And I've had, very, very limited success with this judge. I had a hearing scheduled in front of him this morning. And last week, the judge approved the case on the record. And basically what that means is that, if you look at all the evidence, the judge concluded, a difficult judge, that my client was disabled without the need for a hearing. I about fell off my chair. And when his assistant called me, I couldn't resist saying, did Christmas just come in July or August? And she was just laughing. I'm like, I have never in a million years would expect this judge to approve a case on the record. And she's no comment. I'm like, I'm not questioning it. I'm grateful for it, but wow, I've never seen this type of thing happen. And she's just laughing. But I'll take the win. So I'm waiting for the decision. But I was sort of half waiting for a phone call today. Oh, we're going to have your hearing. Like, well, no, they called me and said no, so it didn't happen. So we were good. But anyway, Rodney, that was the same judge you won with, and I wish I could take credit for it. But another attorney that works with me, Susan Bloom, actually tried that case, and she won. So miracles do happen, I guess. Kelly Drinkwine, and Kelly, you got a very unusual last name, and I did see your case eval. I asked somebody, one of my call screeners, to call you. I was tied up in a hearing today, but I did get your email. And I did have somebody who was supposed to call you. If you didn't get called today, I will get, because I think you got a good argument. I think you have a good case. One of us will call you tomorrow. I have no hearings tomorrow. And so either Angela or Darlene or myself will call you because, again, I appreciate you reaching out. I'm surprised they didn't call you. We had a number of high quality leads today. And like I said, I couldn't participate because I was tied up in a hearing and a bunch of other meetings. So we'll get to that tomorrow, but hang in there. But thank you very much for tuning in tonight, and thank you for reaching out to me. I do think you have a good case, and I appreciate the opportunity to look at it. And Christina, Christina, I'm glad to see you here. Hello from California. I hope you're doing well. Yeah, Kelly, I did see all that, and again, I think it looks really strong. And Christina always reminds everybody to uh, to make a comment, to subscribe, to share with your friends. Absolutely, Christina is an unpaid advocate for my practice, which I really appreciate. And thank you very much, Christina. And you tune in almost every week, so that's very nice of you to do that. Sarah D. My endocrinologist put me on a new medication that has side effects. It makes me use the bathroom a lot more frequently. Aside from diabetes, sleep apnea, other chronic illnesses that could be enough to prove I would need restroom breaks every hour to 2 hours to prove disability. Also, accommodations. My previous employer can no longer keep those accommodations. I'll be getting my copy of the ADA accommodations and FMLA file had from my previous employer for your hearing. To answer your question is, yes, medication side effects, especially those that cause frequent urination once to twice an hour. I've won a lot of cases on that. So absolutely, if you have diuretics or medications that cause frequent urination, that can be grounds alone for, and you said one every hour to 2 hours, that may be enough, to get you over the hump. Because that is a problem. If you look at this through the lens of how do your medical issues and medication side effects make you less reliable, a vocational witness will be at your hearing, and the judge will. So if the judge says to the vocational witness, assume that Sarah D, because of medications, is taking an unscheduled break to use the restroom every 60 to 120 minutes, every 1 to 2 hours. And importantly, how long you're in, and she's in the restroom for 5 to 7 minutes. So what does that mean in an 8-hour day? That means, let's say it's every hour, 5 times 8 is 40 minutes, right? So you're taking a 40-minute break during the day. Now, most vocational witnesses will say you have to be off task for 15% of the day. I think 40 would not be 15% of the workday, because it also doesn't count lunch. But it is a limitation, certainly. And certain jobs are not going to give you the freedom to go to the bathroom when you need to go. For example, a cashier job, if you're in a retail store, you can't go every hour. Most jobs give you 15 minutes in the morning, 15 minutes in the afternoon. Going every 1 to 2 hours is sort of pushing that. But some jobs might, but many jobs wouldn't. You mentioned accommodations, and Social Security is really talking about non-accommodated jobs. So if you have a series of accommodations that was made for you, a footrest, a bigger monitor, a bigger keyboard, software to talk to your computer, whatever those accommodations may be, that takes you out of competitive work and also would make your case that much stronger. So I think that if you could combine the accommodations, whatever those are, plus the need to use the restroom, I win a lot of cases with 30 to 60 minutes. You're talking 1 to 2 hours. And again, maybe there's sometimes when it's 1 to 1.5 hours. I don't know, but you want to think about that as far as how often you have to go. But I think the combined effect of these things, and if there's other side effects of medications, starts to sound to me like you've got a pretty good argument. The sleep apnea would generally mean non-restorative sleep, which means that you would not be able to do complex tasks. And again, I'm looking at this, everything through the lens of how does this affect you at work. So the frequent urination is going to eliminate jobs where you have to be at your job kind of hour after hour and are very limited to specific breaks. I think the sleep apnea is going to limit you to 1 or 2 step repetitive type of jobs, not something where you're going to have to make decisions or changes in the work site or the work tasks. So you start eliminating categories of jobs there, and so you're, I think, on your way to doing that. And again, hopefully your attorney can sort of put all that together and make an argument that there's just too much accommodation needed for you, whether it's the bathroom issues or the other ADA accommodations. We're getting out of competitive work. Therefore, you are, for Social Security purposes, disabled. Sorry about that. Didn't even play that much tennis today. I did work out with the weights, but I didn't play tennis today. So I don't know why I'm yawning here. Cindy G, thanks for being here. My pleasure, Cindy G. I enjoy it. And I hope you find this helpful too. 202.06 is the grid rule. And again, let's just take another quick look at this. And if you see here, their numbers, this is 202.02 and 202.06, which I use a lot, is a person who's 55 plus, high school grad or more, does not provide for direct entry into skilled work, no transferable skills, they're disabled. So that's what 202.06, and that's why I refer to 202.06 as a really good one. So Dennis says, will I get anything from SSA being 58? I mean, again, if you're asking me, are you going to win disability? It depends on the nature of your disability claim. You don't get retirement Social Security until, I think the earliest is 62. But if you're deemed disabled, yes, you would get it at 58. And it's certainly a lot easier to win at 58 than it would be at 48. Harold's got his hearing on Monday morning. Hope you don't blow it. I hope not too. And Harold, again, remember that the judge is looking at you or listening to you. And the question the judge is asking is there any job I can see Harold doing, given the limitations he's got? So at your hearing, you want to give the judge very specific limitations, because again, think about it. If I said to you, okay, Harold, let's determine whether you can do a job. You can't stand very long. You can't lift very much. You're going to say to me, well, what does that mean? What is not very long? What is not very much? So the more specific you can be, the better. So if you say I can only lift 10 pounds or 5 pounds, I can't bend or stoop. I need help putting my shoes on. I am only able to stand for 7 to 9 minutes. I can only walk 30 feet. That's the level of specificity. So you want to be really, really specific about what you can and cannot do. And your attorney should hopefully be able to go through all the questions about your physical. And again, sitting, standing, walking, lifting, carrying, kneeling, crouching, crawling, stooping, climbing ladders, up or down ladders, walking on ramps or inclined surfaces, things like that. Then the mental health ones, focus and concentration, maintaining attention and concentration, working at an appropriate pace, what they call workman-like pace or work-like pace, behaving in an emotionally stable manner. These are the sort of things that are mentally. So you and your attorney want to go through all these factors and identify the ones where you would have trouble and practice testifying about that sort of thing. The second thing I will tell you, and I tell my clients, is when you go to a hearing, every judge is going to ask you certain questions. They're going to ask you about your past work, if you've worked in the last 5 years. So make sure that you know what you did, what your job title was, and be able to describe what you did. That's for the benefit of the vocational witness, but that's something that, again, you're going to be asked, so you might as well be prepared for that. Third thing I would tell you is be prepared to give an elevator speech. What I mean by that is be able to explain to the judge in 3 or 4 sentences why you feel you're disabled. It really helps the judge understand kind of big picture. And as I talked a lot about on this live stream and in my videos, is I'm a big proponent of telling a story. My hearing today, in my pre-hearing brief, I told this guy's story, why he went from working and making good money to not being able to afford his medications and having significant heart issues is what the issue was. You want to tell a story, how you got from being over here to being over here. So think about that. How do you tell your story? What happened to you? and position yourself as a honorable, honest person. If something just things happen to you medically. I talked to a new client today. Gentleman had a heart attack. You know, really bright guy, highly educated, great job. You know, he and his wife were rocking along, traveling, doing all kind of things. He has a massive heart attack out of the blue, and everything kind of changes. All the plans change. Tell your story. So I don't know what happened to you, Harold, but you know, think about telling your story so that you humanize yourself to the judge, and the judge sees, yeah, okay, this Harold is, you know, an honest, hardworking guy who just had some bad stuff happen to him, and if he could possibly work, he would. That's the narrative. That's the story you want to. That's how you want to position yourself. If you do that, I think that goes a long way to making the judge a little more comfortable with listening to what you have to say. Andrea, how are you doing? One of my clients. How are you doing, Andrea? Good to see you here. RD had an ALJ hearing on June 24th. Should you have had a decision? Yeah, you should. I mean, we are now, 6 weeks out? I'm getting my decisions in 3 to 4 weeks. You know, 6, 7 weeks is not unheard of, but certainly by the time you get to August 24th, you're at 2 months. I would start questioning. And again, your attorney can reach out to the hearing office to find out what's going on, but that is it seems like a long time now in this current climate. And Harold says he's been waiting 4 years for his hearing. Again, a long, long time. That won't, you know, and you may have a judge even say, you know, Harold or Mr. So-and-so, on behalf of the agency, I apologize for the long delay. Not going to make the judge approve your case, but you know, if the judge says that, at least he's being sensitive to the fact that you've waited a long time. Zippy says, what would happen if your CDR letter got lost in the mail, not knowing you're under a CDR? That's a problem. Now, I don't know whether your My Social Security account would show it, but that is a problem. If you have an attorney or had an attorney, sometimes your attorney will get the letter as well. When I get those letters, although I'm trying to think if I really ever see any of those. I'm not sure that I really do. So maybe that your attorney wouldn't get it. You know, if you have reason to believe you're under a CDR, then I'd reach out to Social Security. But yeah, that's a problem because if it gets lost in the mail, you know, they're going to assume you didn't respond to it, and you know, they cut your benefits off and they move to terminate, all that kind of stuff. So I would, at a minimum, I think if you have your My Social Security account set up, I think you would see it there that there is something going on that at least would prompt you to call. But if it got lost in the mail, it's a problem. And that's why I have a My Social Security account. Essays coming. This is the first question I talked to. Microdiscectomy is a lumbar surgery the orthopedic wanted to do. Yeah, that's a little less, excuse me, invasive than a fusion. But yeah, it is a back surgery. Any back surgery can be a problem. So, you know, not going through that is not an issue. And yes, you've had major problems with medical facilities. They love my insurance or making me broke. Yeah, you know, look, medical facilities, and as much as we like to think that doctors are, you know, selfless and they're out for, you know, to help everybody, they're businesses. Look, law firms are businesses. I'm not apologizing for that. I don't think doctors are either. And, you know, in SA's case, what we have is, you know, a new practice is saying, well, even though it was done over here, we want to do it ourselves. They will make money from that, and they will satisfy the government that they are not dispensing pain medication without, you know, thorough evaluation. So yeah, that's what's a little bit what's going on. Luke, what's the average response time for getting a case evaluation from my office? What's the process like? Well, what people do is if you go, and I'll tell you exactly what I do. You go to the contact screen and you'll go to, I'll show you the website here. Let me just open it up. SSD, oops, that's the wrong one. SSDanswers.com. Let me show you this so you can see it. Share screen. Okay, so I got several websites. Here's one of them. That's got me, a lot less gray hair there, don't you think? But that was me a couple of years ago, at least. So you can sign up for the survival kit, which comes by email. I've got all this stuff, tell me about how great I am. I didn't write all this, but somebody, web developer did. But obviously it's under my name. But here you can ask for a case evaluation, and basically it comes to me. And so every morning I get case evaluations that come in, overnight, and I usually check during the day as well. And if I have the bandwidth, and we have call screeners, and I've got staff, I'm looking at cases that I think are really solid, and let me stop the sharing here. And if it's something that I feel is a good fit for me, I will either call, or I will have Angela or Darlene, my two case screeners, call. Madeline, when Madeline is on summer break right now, but she's also been a case screener. And one of us will call and talk to the person and get details, because sometimes, the details do make a difference. I mean, I've had cases where somebody hasn't worked in 10 years, so they wouldn't be insured. That may be maybe less inclined to take a case, or they have another attorney, wouldn't take that case, or there's some other issue. But assuming that it's viable, then we'll go ahead and proceed. There are some cases where I look at and say, this is maybe a better case for somebody else. I've got 2 or 3 lawyers that I do referral business with, and sometimes it's just I can only handle a certain amount of cases. I refer out to 1 or 2 of these folks. There are a couple of them. There's one lawyer in particular who has a real sort of subspecialty with mental health cases, and so many times I will refer those out. And there's one lawyer who has a practice that is kind of in a geographic area, and anything coming in from that geographic area, I'll refer that out. There's one lawyer that deals with cases that have already gone to a hearing and been denied, and then there's a new application. And so again, I just try to find the right fit. But that's what happens is I look at every single one of them. If it's something I can help and I can do it, I will grab it, because obviously we're trying to build our practice. If it's something that I think I'm not the right fit for, I'll refer it on to somebody else, and they will contact you. So that's what happens. Okay. But yeah, Luke, if you want to send me a case eval, go to ssdanswers.com, and I will I'll respond to you regardless. So you'll hear from me regardless, because I'll look at every single one of them. Zippy says, this is the person, I think, let's go back up here, is what would happen if the CDR got lost in the mail. All right, so Zippy, you are 60 and a half. You've been on SSDI since 2022, the award letter 5 to 7 years. All right, I think, Zippy, it's very unlikely you're going to get reviewed. I think that anybody at 60 is not their target. You are real close to retirement age. 5 to 7 years really means no review. They're not expecting you to get better. So I think that the odds of a review, unless it's one of the random ones, and they do sort of send out these reviews sometimes randomly, I think it's really, really unlikely. And I think if you have your My Social Security account set up, you would see it. Check that every month or so. But I think it's very, very unlikely at age 60 you would face a review. An essay is coming back here. This is the person who was proposed a microdiscectomy that is not happy about that and gone to another practice and wants to do all the tests again. Can't take narcotics or onions. I think you meant opioids. I probably could take onions, but maybe not. But I'm guessing opioids due to long-term prescription benzo use. I would stop breathing, went on myeloduplication, not bold to speak up strongly. Again, opioids. Yeah, I think that's what you meant. I just think that this is just an example of procedure, form over substance. This is the way we do it. So you do it this way. Yeah, but it makes no sense. We don't care. This is the way we do it. And, the problem with speaking up, quite frankly, is you don't want to get off on the wrong foot with a new practice. You don't want them to fire you and basically say we're not going to take you. I'm almost telling you, bite your lip and just go for it. Just go through with it. I know it's ridiculous, but you could certainly respectfully ask why they need to do all this, but my guess is you're not going to get anywhere. Rob Jewell, 100% disabled combat vet. Thank you for your service, receiving benefits. Slated for ALJ hearing on October 9th. So I'm guessing when you say receiving benefits, you mean VA benefits. That gets you to the front of the line. Your VA status is a factor. It is not a controlling factor in your disability. So if you're 100% VA disabled, Social Security will look at that. The records obviously will be relevant, but the fact that you're 100% VA does not mean you automatically get Social Security. Now, why you would have two federal programs, disability programs, and there are other ones too, by the way, but two, the big ones, VA and Social Security, that have different definitions of disability. Does that make any sense to you? It makes no sense to me, but that's the way they do it. So it's a different definition of disability. Therefore, one is not controlling on the other, but they do recognize it. What that means when they say they recognize it, it is a factor. And I'll just leave it at that. I think it's a factor, but I've had enough cases with 100% VA disabled vets who have been turned down by Social Security, especially when the issue is PTSD, that I don't know how much consideration they give it. So whatever that's worth, that's been my experience. Recently, Connie says, recently completing cognitive psych evaluation and the test results. I am past 50. Let's see. Oh, wait a minute. That's the wrong Connie. I'm sorry, Connie here. And you have test results. So again, if you've gone through the psychological consultative or cognitive test results and it shows a significant issue, that would be grounds for pursuing disability, but it's got to show something. All right, Alicia, one of my clients that we won our case, already been contacted, told I'm not covered by state Medicaid, told I'm picked up by Medicare, I have to pay out of pocket. This is an ongoing issue. And what is, people get on Medicaid because they are, indigent, and they are medically needy. And then they get on disability, and disability Medicare does not kick in until 2 years after you're first eligible. So there could be this gap where you're not covered. What I would do, Alicia, I would go back to the Medicaid office and see if there's any program that you could fit into to cover this gap, because it just doesn't make a whole lot of sense. And I know that some of the Medicaid offices have different rules for Medicaid. I know for children, there's something called the Katie Beckett waiver, but don't just take that as gospel. I would look into that a little bit. But yeah, this is a problem if you are going to have to wait for your Medicare. It's kind of a balancing thing. On one hand, you got money coming in from disability, but if you don't have access to Medicaid anymore, you've got to pay for out of pocket. It's definitely an issue. You might also reach out to Cal Hero. He's an insurance guy that I've interviewed before, and he deals a lot with people on Medicare and all the supplemental policies. Might be worth talking to him, see if there's anything that he could do on his end. I don't know if there is or isn't, but his website's MedicareMall.com, and I think it's info@MedicareMall is the email address. But if you just email me, I'll put you in touch and make the introduction. But that may be an angle there to go as well. But yeah, that's what you're describing is a real problem if it's going to be, a year and a half where you have no source of insurance. But let's put our heads together and see if we can figure something out. Annie's Shenanigans. 62 getting SS now, so I'm assuming retirement. I applied for disability in July at a phone interview. 2 weeks ago, attorney says it was 4 reps, so they should have prepared me. I feel like they did this because my case was soon to be financially beneficial. If you're saying, did the attorney do something to try to delay the process? I'm going to say no. I mean, look, I have cases every, I'd say 3 or 4 times a year where we file an application and the person gets approved within the 5 month waiting period, or Social Security changes the onset date and there's no past due benefits and there's no fee. As an attorney, my obligation is to my client. So, for example, I had one about 3 or 4 months ago where they changed the onset date, no fee because there's no past due benefits. So I told my client, I said, look, the issue here is that they approved you as of your 55th birthday. We could appeal this, but you're putting the whole thing at risk. He's like, I don't want to do that. He goes, but you're not going to get paid. I said, you're right. Write me a nice review. Ethically, we are not allowed to put our own financial interests ahead of the clients. So it would be improper for an attorney not to help you get a fast approval if that was something that was reasonable thing to do. Um, so the phone interview with Social Security is generally not something that you can really prepare for. Honestly, it's just they're going to ask you some questions. It's not adversarial. So I'm going to come down on the side of your attorney. I don't know who your attorney is, but um, the attorney's not going to make a whole lot of money out of your case anyway. I'll just tell you, because you're on retirement. So that what you're going for is the difference between retirement, early retirement, and or I guess early retirement Social Security and full retirement Social Security. So maybe $500 or $600 a month. Um, it's just, no attorney is going to risk their license for, a couple $1,000s of fees. I take cases like this sometimes. It may end up with a fee of $1,000, $750, whatever. You also can get hopefully you get my client will write a nice review out of it. But I don't think the attorney intentionally did think. I will tell you this, I've never not done something to help my case, help my client, to cause delay. First of all, if you can get a case approved without going to a hearing, you should, because if you look at the list of judges, you could draw a wild card judge. And I have had a couple of those. 12%. There's a judge in Charleston, 12% approval rate. There's a judge here I've mentioned before, 22% approval rate. There was a judge in Atlanta who recently, thank goodness, retired, 17% approval rate. Nobody's going to want to roll the dice with that. And every hearing office has one or two low paid judges. So, you can get a case approved early, be happy with whatever fee you get. And, the claimant's going to be, your client's going to be happy. But I don't think the attorneys do anything to delay it. I just think that's just so unlikely, in my opinion. All right, and Alicia says the state SSIs are telling SSDI will be, so I'll be able to apply for state ACA. I'm not sure what state ACA is, so I don't know what that means. What ACA is? I'm sorry, Alicia. Tell me what that means, and I'll see if I can answer that better. Okay, 55 with, okay, and again, partial question there. Jeremy says, what is SSA's view on 100% permanent total combat veterans with TBIs? It's hard to say what their view on it is. I think that, again, 100% permanent total disability gets you to the front of the line. I think that there have obviously been a lot of combat vets with TBIs, and so they see a lot of VA treatment records for TBIs, and those records, can be very helpful because the VA is set up to deal with that. So I think they'll probably give that a decent amount of weight. I mentioned PTSD before because we still see a lot of PTSD cases from veterans. A number of years ago, there was I'll call it a scandal, where there was a leaked email where a VA undersecretary sent out an email blast to a bunch of VA directors saying, tell your doctors not to find PTSD because we're going to get stuck with all these VA claims. And that got brought into the press. And of course, the VA does an about face. Oh, no, no, we really honor our veterans, and we recognize PTSD, blah, 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 blah. Bunch of garbage, but that's what they said. So, VA treatment records, I will tell you, tend to be voluminous. They tend to be really, really large. The VA tends to do a lot of group therapy, which is a little less, convincing when it comes to records. They tend to put copies of copies. So if you go to a VA doctor, you may see the record for the last 10 visits in that record. Then the next time you go, the last 11 visits. So you look at 30 or 40 pages of VA records, and there are 2 pages that are unique. The rest of it's copies of copies. So VA records can be hard to go through, but if you can get through the gist of it, I think that if you have a TBI and you've been treated for the VA, and it's very hard to treat a TBI because you've had organic damage, structural damage to your brain, and no medicine is going to solve that problem. So I think generally TBIs can lead to physical limitations. They can lead to psychological problems. And if it's well documented that you've got a TBI and you have all these symptoms, then those can be good cases. I think TBI cases are better cases, at least from my standpoint, than PTSD, because again, you're dealing with something that is organic. Many times it can be imaged as well. So I think those are pretty good cases. Let's see here. Cindy says, always helpful. Thank you, Cindy. Vincent Costanzo, are all ALJ, not ADJ. Here's my phone. Why do they send me 2 forms to complete to object to a video call in person? The default now is phone. You can also do a video call using Microsoft Teams. My case this morning was a video case. You can also ask for an in-person hearing. I will tell you, some attorneys feel very strongly that in-person hearings give them a benefit. I don't. I have not seen any difference at all. If anything, my approval rate is higher with virtual telephone or video hearings than it was with in-person. The other problem with in-person hearings is when you go to one, they are still using all the masks and all the COVID protocol. So they will literally have one person in the hearing office at a time, and the next hearing will be 15 minutes after that. So it's much slower to get a hearing date. I've done, I think, 2 or 3 live hearings since COVID, since 2020, and it was like a ghost town walking in there. So I personally don't see the reason for it. And of course, Social Security with this form, it's like negative notice form. I mean, you can object to a video hearing, and you can, there's a form I give them that basically says, it's from NOSCR, the trade organization, that says we want a telephone hearing and we want a video hearing. So my personal thought is an in-person hearing is less desirable because it takes longer. A video hearing is fine, except that stuff goes wrong. My hearing today, and again, you see, I got 400 videos. I do a live stream. I'm not, not new at this. And I got on Microsoft Teams and nobody can hear me. Okay. I can't hear anybody. What's going on? They could hear me, but I couldn't hear them. And I'm looking and looking. And finally, I got a headset, plugged it in. Well, I finally looked on Microsoft Teams on the microphone setting. That's where you set the output device. And I'd actually called my client. We'd done a Microsoft Teams practice run the week before, and everything worked fine. But for some reason, this is what happens. So in my opinion, video hearings, there's more stuff that can go wrong. I like telephone hearings. Video hearings are fine, but to me, there's not the advantage of seeing the judge is not worth the technical issues that can come about. So my opinion is go for a telephone hearing as opposed to video or in person. That's just me. And again, you may have an attorney that wants a in-person hearing, and that's fine if they do, but that's just not me. Rob is a 55-year-old, 100% PTSD combat vet, monthly payments from the VA. I'm going about to my first ALJ hearing. I do have an attorney representing you. Again, PTSD is tough because they see a lot of it from combat veterans. So you've got to go beyond just what everybody who has PTSD will testify to is they're hypervigilant. They go into a restaurant and they're sitting in the back of the room. They can see, they can see out front. They don't want to be somebody going behind them. They will say many times that they are very, very sensitive to loud noises or flashes of light or war movies. Okay, that's the typical testimony. So you want to get more than that. I think that you want to say, how your PTSD affects you is more than just that. That maybe it affects you in terms of your interpersonal relationships, or you tend to fly off the handle when you're dealing with coworkers or supervisors, or your focus and concentration are significantly impaired, or you have crying spells, or you're easily triggered. You want to make sure you know what your triggers are. I would talk to your attorney about, what beyond the normal hypervigilance and the normal not wanting to be around people and the normal, avoiding loud noises or bright lights. You need more than that, in my opinion. So I would talk to your attorney about what more you can get. Akeem Smith, I have no idea. I know nothing about that. All right, Rob, I think you just answered as far as a favorable decision. You need more than the standard stuff, is what I'm telling you. So talk to your attorney about, what is kind of what everybody, those of us who do this, you sort of see the same PTSD symptoms. Everybody's got certain symptoms. You want to go a step above that if you possibly can. All right, Brandon Spears. I'm 41, have a GED of 3 severe bulging disc, 1 herniated disc with nerve impingement at L24, sciatica nerve pain, in pain management, physical therapy, and MRI. Let's see, anything else from Brandon here? That's it. Okay. I would say, Brandon, that the big issue is you're 41. That means that you have to prove that you cannot do anything at all. And imagine a simple entry-level job. You're watching ink pens in a box. I think I sent you, I think I showed last week the video of the guy sitting in the assembly line watching stuff come down. So you got to show you can't do anything at all. That is a burden. The fact that you're 41, there's a little bit of a bias against you. On the other hand, you've got herniated disc, you've got nerve impingement, sciatica and pain management, physical therapy. This is going to be a judgment call by a judge. You've got a lot of stuff going on. If you were 55, you got to win. At 41, you got to convince the judge that you really can't do anything at all. And so hopefully you get a judge with a reasonable approval rate, because you've got, good impairments, but, the fact your age is going to be the big issue. Connie says, does SSA usually approve or deny disability claims for 62-year-olds after reviewing cognitive results? At the administrative level, don't take their non-approval to mean anything. It just could be they were too busy. But when you get to a hearing, if that cognitive and psychological assessment shows significant problems and you're 62, I think that goes a long way to getting you approved. So I would be hopeful. Okay, so Rob says your ALJ has a 31% approval rate. Should I be worried? Rob, you are 55 with PTSD. I would say you always want to be worried about a judge with a 31% approval rate. On the other hand, judges with 31% approval rates are approving 31% of cases. Who are they approving? People over 55. So, in that regard, you're better positioned than if you were 35. But yeah, it concerns me to have a low approval judge. I think that, you need to be very, very descriptive about your symptoms. Okay. I'm not sure, Connie, what you're asking me. RD says hello from California. Hello, RD. Okay. Looks like these are the symptoms that came across: neurocognitive disorder, major depression, generalized anxiety. Okay. And those are important and limiting diagnoses, but what does it mean practical? what does that mean in terms of your functioning? So, you've got to identify the functioning issues that are consistent with those diagnoses, is what I would tell you. All right, Shub 281. I think you're the Phillies fan. I think you're approved in May. 5 to 7 year diary, both knees shot. I have surgery. Well, I lose SSD. I'd be 59. Then, but I was a commercial truck driver. Could be medical improvement. I still think you're under the grid rule because even with replacement knees, are you going to really want to be lifting 50 pounds? Probably not. There may be other issues you got going on there. And plus the odds of a review after 55 are really low. I think that it's probably, you say a few years, so you may be over 60. The odds of a problem are just really low. I just don't, to me, that would not be a reason to not go under surgery because of concern about a CDR. Christina, and my wife, most of my family are attorneys, my kids, okay. Workers' comp. She does Georgia workers' comp. I'm nationwide. She's just in Georgia. I do have a daughter who's an attorney. My daughter is, she does a little work for us, my wife more so than me, but she is a clinical bioethicist for a hospital chain. What that means is that when people come to the hospital, either that don't have capacity to make decisions or they're unconscious or there's a debate about what the decision needs to be, she does family conferences to try to help families come to the right decision. Sometimes it's letting nature take its course. Sometimes it's, getting them to a long-term care. Sometimes it's agreeing to surgery or not agreeing to surgery. So she's doing a lot of, I guess you call it counseling, which is being a lawyer and a counselor. And she also does a little bit of work for my wife, kind of part-time. And she's done a little work for me as well, but she is an attorney. My son is not an attorney. He is a project manager for Adobe, a big software company, and is not an attorney, although he does my videos. He will edit my videos, so he's learned a lot about what I do just by watching the videos. And but they're both off the payroll. That's the best part. They're both off the payroll, except for the cell phone. You never get your kids off. Just so you know, if you have kids that are 10 years old, 5 years old, 15 years old, they will never get off your cell phone plan. I don't know why that is, where it's written someplace that your kids never get off your cell phone plan. They may be independent, making good money, married, have kids. They're still going to be on your freaking cell phone plan. Can't get them off. My wife, I just let her worry about it. Okay, I'm paying the bill. But, it used to be on the Netflix plan, but now Netflix won't let you do it. But I'm paying their cell phone. So, and when they complain about the service, well, we don't get great. Okay, you want your own? Well, that's okay. So, but other than that, they're off the payroll, which is nice, and they're doing well. And I got a grandchild, almost 2-year-old grandchild, who is awesome. My daughter's daughter, and hopefully my son will get married off at some point in the near future, and we'll have more grandchildren coming. Right now, I got one, and best thing ever. Much more. I would recommend grandchildren over children every day of the week. Much easier. You can send them home. When they break stuff, you don't yell at them. You just tell them, Mom or Dad, take care of it. So whatever it's worth. Okay. Amy Mickey. I'm 56 and legally blind to neuromyelitis optica. That's our neurological issue with the optic nerve. Major depression, severe social anxiety. I'm a high school grad, left my job, new division, applied to SSD. Well, there is a listing for vision issue. You want to look at that listing. Let's see which one it is. If you go to meetalisting.com and you look at, I believe it's listing 2, and there are 3, 2.02, 2.03, and 2.04. I'm not going to go through all those, but look at those to see if you meet or equal a listing. The major depression, is probably not enough on its own. I mean, my experience with mental health is you almost need to be in have been hospitalized or had suicide attempts or had many failed drug trials. Sounds like the depression is going along with not being able to see and not being able to work, social anxiety. You're 56. The grids will not apply here, probably because you're not physically limited. Although I would argue that if you can't see, then standing and walking could be a problem. It's a little bit of a stretch because you have the capacity perhaps to stand and walk, but because you can't see, it's dangerous to do so. So maybe you squeeze in and make a grid rule argument, but anybody over 55 is going to be given a little more leeway anyway. But I think what I would do here is I would make a functional capacity argument. The combined effect of all these conditions would make me not very reliable at work and limit the number of jobs I could do to such a small sample that there's really no jobs out there. Maybe make a grid rule argument to say that even though I don't have physical limitations because of my vision issues, I can't stand and walk 6 hours safely. And unless I'm in one place, and that is not very likely you're going to find a job where you're in one place for that long. There may be a couple of jobs like that, but probably not real likely. I think this looks more like a functional capacity argument here as opposed to grid, but maybe a listing. So look at the listings again, 2.02, 03, and 04. Go to metalisting.com. I'll put the vision listing in the note or in the comments here, so you can see it, because I know you probably can't see very well because you got vision issues, but somebody could write that down for you, and see what you can do. But that I think you've got two arguments for disability at the very least. This is life. Under 40, first CDR was sent to DDS 2 months back in June. Got good documentation. RFC form showing moderate to marked limitations. SSA hasn't faxed my doctors yet. Did I pass? I don't know. It may just be they haven't gotten to it yet. That's very not uncommon. So it could be that they just haven't gotten to it yet. So unfortunately, don't relax. I can't tell you to relax at this point, but be vigilant. I'm 56, says already. I have peripheral neuropathy in the left foot, which means nerve pain going into the left lower extremity, nerve root compression. My doctor signed for the DMV disabled plate. Will this help? Yes, it will help. Other impairments? Yes, that will help. I think that, the peripheral neuropathy is going to get rid of a lot of jobs, and the pain may get rid of all the jobs, but those are very, very relevant things. This is not something, this is a political question about COLA, cost of living increases. So that's not something I do. Unfortunately, I think you have to contact your elected representatives. Sam I am, a Dr. Seuss fan. SSA states my ALJ decision is being reviewed to see if I still meet the non-medical requirements. What does that mean? What that means is they are looking at your earnings record to make sure there's no earnings after onset. Realize that when you do your taxes, let's say you do your taxes for 2024, you filed them April 15th of 25, or you got an extension to file them September 15th, I think is what the extension is. Social Security is not getting this information in real time. They have to ask for it. It posts, at the end of the calendar year, but, a lot of stuff happens in the meantime. So they just want to make sure that you are not working and earning over SGA level work since your onset date. That's what they're doing. If you haven't worked, this non-medical review is it's frustrating, but they go through it every single file. But that's what it is. Because they're not looking at the medical. They've already decided the medical that you're approved. They just need to make sure you qualify for the program. They have to recheck the numbers to make sure that you have enough earnings credits. They need to make sure there's no recent work. Things like that. That's the non-medical side of it. It's just the numbers part. Dominique, the judge reviewing my case. The last word was no jobs to my attorney, but but 3/4 to the judge of the case was wrapped up. What does that mean? I'm not sure, Dominique, what you're asking. Your attorney asked a hypothetical question, got answered, there's no jobs. Well, your attorney probably made it very, very restrictive. but 3 out of the 4 questions the judge asks, there were jobs. So the judge is going to choose one of these questions to reflect the decision. If there's one of those questions, the answer was no jobs, you want to hope that the judge picks that question. If the judge picks a question as your profile for where there were jobs, then you're going to lose. I hate to put it that way. That's just the reality of it. Keisha May. Nice name, Keisha. I like that. I always thought May is a nice middle name. Got overpayment last year in March. They put back in September. Then on June, they added $2,500 SSI. And this, they take off 95 and I got overpayment again. This might be a situation where you reach out to your U.S. Senator's office for help understanding what's going on and not being whipsawed with this overpay back and forth. Sometimes the SSI letters cross in the mail with SSDI, and so they'll say you get this, and then they'll say you don't, and then it's offset. It gets very confusing. I would probably try to get somebody from your senator's office to help with that. Christina says, please leave a 5-star review. Thank you, Christina. Let me put the link there. So yes, if you have gotten value out of this, or if you are got value of the videos, or you're one of my clients, and you're willing to write a review, I'd really appreciate it. I had a gentleman today, as a matter of fact, he asked me a question about, I think it was a CDR, and I can, when I don't have time to answer every single email, but if I can answer a question quick, I'll do it. I just sent him an email back, answer his question. Thank you so much. I said, would you mind writing a brief review? Absolutely, he did. Wrote a nice review. It really helps me. I mean, we're, as I said before, law is a business. And people rely on online reviews. Actually, I had one 1-star review. This guy had won his case, and he was pissed off about something, and he wrote me a 1-star review. I'm like, I won your case. And something he did afterwards, I don't know what the problem was, but bottom line is I just didn't respond to it. But yeah, the more reviews I get, the better, because it really helps people find me. So please, if you're so inclined, please do it. Deharjun, no, I'm not sure how you pronounce that. I was working during the wait. I earned $1,200 a month. Okay, so you apply for disability, earning $1,200, which is less than $1,620. Now that you approve, those earnings count as a TWP trial. Yes, they will. They absolutely will, because you're over the TW. I think trial work period is 1160. Let's take a look here. Trial work period 2025 is 1160. I was right. So if you got it below 1160, you wouldn't use up your trial work period, but you're above that. So yeah, you're going to start using up your trial work period months. So try to get it below if you can. But it would count. Zippy says, thank you, Zippy, for tuning in. I appreciate that. Dad, love your videos. Just watching them help me make it through the process. Thanks. Very good. Well, thank you, Dad. I appreciate that very much. That's why I do them. And look, I hope that I get emails, I'll tell you, I'd say 10 a year from people who've won their cases watching the videos. And I'm cool with that. That's great. I mean, I'm thrilled people can win just by watching my videos. I'm a big believer, like I told you, narratives. Also a big believer in karma, which means you send something good out in to the universe, it comes back. And, it's really important to help other people. And so, yeah, I think that it's just the right thing to do. And so, I'm not a saint, and goodness knows I've made my share of mistakes, but you try to help people, nothing bad happens out of that. Good stuff happens. So happy to do it. This is life. Hey, Jonathan, I'm under 40 and ALJ sent a light RFC off test greater than 10% from chronic fatigue, moderate limits. Under 40, so this is a strong precedent for the ALJ initial bar for predictive future reviews. I don't think that the Social Security looks at the hypothetical questions or the reason for an approval. To my knowledge, I think they're just looking at it to say, do you meet the standard for disability now? But I could be wrong about that. That's a really good question. What you're asking me is, when they're doing a CDR, now I'm thinking about this, do they look at the favorable decision to see what the basis of it was, and has that changed? That's a really thoughtful, good question. This is life. Let me ask. Greg Brinkley might have an answer to that. That's a really interesting question. I don't know. I don't know. That's a really interesting question. We'll see if we can find that out, because I'd like to know myself if you know the CDR is going to look at the prior approval. Don't know. Mr. P. Um, okay, you got approved working part time. Yeah, it's more and more common now because so many people do it. SSA, send me to get X-rays and internal medicine journal exam and mental status exam next week. Okay, a couple pieces of advice, and you probably see this in other videos, but I'll tell you anyway. Number one is, they will, when you drive up, they're going to watch you walk out of your car into the waiting room. So, be truthful, be honest, but they're going to be watching you. If you normally use a cane, use your cane. They're going to be watching you. Number two is, these doctors, these consultative doctors, both physical and mental, are trained to look for malingering, secondary gain, drug-seeking behavior, things like that. So tell the truth. Don't tell them what you think they want to hear to help your case. Just tell them the truth. If you can do something, fine. If they say, can you spell this word backwards, spell it backwards if you can. Don't try to play any games with them. That will backfire on you. I think for the consultatives, I would write down everything that happens, let your lawyer know, because sometimes these are so brief and nothing is done, you can argue they shouldn't be given any weight. I've had cases where people go to internal medicine consultatives, and the doctor doesn't take reflexes, doesn't take their pulse, doesn't touch them at all. And then you see this report with all these things, reflexes are normal, and this sign is normal, and that sign is normal. It's form letter, and it's garbage. But, if we have a report from the claimant, literally the day of the exam, and it says all these things that the doctor didn't do, that's evidence. And, I could use that to object to the findings of the CE doctor. So I think that, you just want to really know what happened, write down what happened as much as you can. If you can record it, record it. Some doctors don't want you to do that, but if you certainly can write down what happened, and just tell the truth, don't exaggerate, tell the truth. If you can do something, say, I can do it, but if you can't, and if the doctor asks you about your activities, what you can do in a typical day, don't think of your best day. Think about, on a scale of 1 to 10, if 10 is your best day, 1 is you're close to death. Think of it like a 4. Not the worst, not quite the middle, maybe a little low middle, and kind of what you do. And just like with the judge, have specific answers. How long can you do? Can you sit? Can you stand? Can you walk? Can you carry? Don't say not very much. Be specific. Just be specific. The physical medicine doctors a lot of times are not there to help you. The consultatives typically are practicing doctors, and they tend to be a little more reasonable, I would say. So just tell the truth. And I've got a couple of videos about what to look for, but bottom line is just tell the truth and don't exaggerate, and just be aware they're going to be watching you coming in and coming out. Keisha's getting conflicting letters from SSI. You would just wait till all the letters stop, and you may have to put them all together. If you have an appointment, maybe you could ask them. What I sense is happening is you're getting different letters from SSI than from SSDI, and SSDI offsets SSI. So they send you one letter saying they're going to pay you, then the next day we're not going to pay you. It gets very, very confusing. So, you may want to just look at those letters kind of in sequence once they all come, and it may make a little bit more sense. Michael Chillers, do you write briefs to the DDS stage? I'm your client. That's the stage I'm at. I have been doing more of that. Michael, it just depends on what evidence is in the file. Basically, when we get involved in the case, we send Social Security a letter saying, please give me electronic access. And many times we get it pretty quickly within a few weeks, and I can see what's coming in, and I will look to see what's coming in. Now let me just for, since you asked me the question, let's see what's going on in your case, if I've got access and what's there. Okay, so I do not yet have access to your file. So once I do have access, and sometimes it can take 3 or 4 months. I don't have access yet, but when I do, I can see what they've got. If they've got, a couple of 100 pages of records, I'll look at those records along with your intake questionnaire, and I may start I use, this is just me. I do a hearing worksheet, which is basically where I have all the facts of the case and I summarize the medical. I may start that really early if I've got access to the medical record. And if it looks like I have enough to write a brief on, I will send at least a letter to the adjudicator setting out the theory of my case, if I think there's a decent chance for an early approval. We're kind of formalizing this because I really like to get early approvals. It just makes everybody happier. And, the positive publicity will more than make up for, the loss of fees. So I'm looking it's actually going to be called Operation Early Approval to get to early approvals. So in those cases where I think I can do it, yes, it'll be a letter, won't be a formal brief. It'll just be a letter to the adjudicator. Well, I'll set up my theory. There are 3 theories of disability, listing, grid rule, functional capacity. And if I get a sense that I can do that and it'll have any value, I'll do it. If it's a case where I know they're never going to approve it early because of, there's been a prior, the prior application that was not appealed, or there was a prior hearing decision, or the person, the evidence is not, it's chronic pain, there's not objective evidence, or it's orthopedic and it's not listing level, they're not going to approve it. I'm not going to waste everybody's time. But, I may start my worksheet, I may start my brief early on. But answer your question is, yes, I do, but not every single case. Whereas at a hearing, just about every single case, it just depends. So the starting point for you would be when I get access to your file, which I don't see I have. I put in chillers in here, and I'm not seeing that I've got access to your file yet. Okay, so when we get it, we can talk about that further. Tim, how you doing, Tim? We applied at 61 and a half. I turned 62 prior to any approval. Do I file or wait? That is up to you. If you go ahead and take your early retirement, that gets you money coming in. Then what you'd be going for would be the difference between early and full. And that may be $600, $700, $800 a month. If you don't win, and I think we're going to win, but if you did not win disability, you are forever stuck at the early retirement number, which is like 75% of full retirement. If we win, or when we win, they'll knock you up to full retirement. If you need the money, go for it. That's what I used to tell people. Don't hesitate to take it, because it's money's coming in, and if you can do it, and only if you just really don't want to take that risk. Let's see what we got on you. Nothing here yet either. Okay. Yeah, I just think that just if you need the money, go for it, and you're just now going for the difference. Okay. Akeem Smith, why you get that much in SSI and SSDI? The most you get now is like 4,000. That's the highest you would ever get. I just had a case today. It's going to be the person's going to be benefit will be $4,000 because that's the highest you can get in 2000. I think it's 4,003 or something. 2025. Cindy G, thanks. You're welcome, Cindy G. Okay, John Chestnut, good question. Can you explain transferable skills regarding the grid? So again, at age 55, Even if you could do light work, you were disabled, assuming no transferable skills. And basically, transferable skills is where you have skills that you could take from job A and put it to job B. So, example would be if you did customer service work um, at job A, that was, and that's not a great example, but let's say that there was a physical nature to it. You were working in a auto dealership parts department and you're doing customer service, and that required you, as they do sometimes, to go physically get boxes of parts, carry broken parts, and it was a medium job where you're having to lift 50 pounds, but you did customer service. Well, a vocational witness can say, because you did customer service in a medium occupation or a light occupation, there are customer service jobs that are at sedentary or light, so they're physically less demanding, where you wouldn't have to be carrying boxes of car parts. You might just be in an office environment. So if you have transferable skills, and examples of skills would be the ability to sell over the phone. It's not characteristics like intelligence, it's things you have not physically, things you've actually learned. Customer service, using a database, um, you know, um, managing people, doing payroll, things like that. And these are skills that you've acquired: computer skills, um, word processing skills, writing, being a writer, handling certain math issues. These are all skills that would transfer to lighter jobs. And again, there are situations where you're doing the job in a physically demanding environment, and the vocational witness would say there are, or even a light job where there's occasional lifting and standing of 6 hours occasionally. The job may be classified as light, but there are sedentary jobs that could use those skills. And so that's where I usually see it, is the vocational witness will say there are skills that this person acquired at this light level job. And if you go to the Dictionary of Occupational Titles, flawed as it is, occupationalinfo.org, you will see there's a lot of light jobs. And again, if there are, clerical jobs, there are jobs, customer service jobs, math jobs involving math, things like that. There are also sit-down versions of these jobs that, you could do. Let's say an executive assistant could maybe transfer to being a typist, a clerk typist, or receptionist, things like that. So that's what it means, is basically skills that you've picked up at one job would transfer to a lighter type of job. And that's how transferable skills become a problem. I mean, transferable skills are not a good thing for me, because that means I can't use the grid rules. So if a person has a lot of transferable skills, that's problematic. Now, there are some jobs where the skills are so unique to that job that they're not transferable. So let's say that you worked in um, a cannery. I don't know why I thought a cannery, where you're making, you had a job operating a machine or doing some function to can, vegetables or fruits, and you're operating this particular type of machine. And that's all you've done the last 20 years. Well, you may have skills to operate a machine, but there are probably not other cannery jobs that are light or sedentary, that your job is so specific to that industry, it wouldn't help you. I've had cases where people are ultrasound techs, and so they have skills operating medical equipment that could transfer. But if all they know is ultrasound, and that happens to be a physical job, because many times the ultrasound tech has to move the equipment. A person may be obese or not able to move. They have to lean over, they have to lift. It can be a physically demanding job, but operating medical equipment is transferable skills. So I've had vocational witnesses say that that the skills that a person acquired being a radiology tech, uh, there are skills that exist, but they're so unique to that occupation that they don't transfer out of that. Therefore, there are no transferable skills. So that's one way to get rid of them. A second thing is there is something out there called the POMS, POMS, which stands for Program Operation Manual. And there's a POMS section that says that if you are age 55 and limited to sedentary work, or age 60 and limited to light work, that any transferable skills analysis has to use something called a minimal vocational adjustment standard. And what that means is that if you are 61 years old and you have transferable skills, that the job that it would have to transfer to essentially has to be identical to what you came from. So they're not going to expect a 60-year-old to learn a new industry. So let's say you were working in car parts and you have skills operating computers, customer service, whatever the skills are. They're not going to expect that you're going to be able to go into a flower shop and learn that industry at age 60. So the older you are, the better the argument's going to be that your skills are not really transferable outside of your job. Although I have made that argument and successfully in younger people as well. So if your skills are really unique to your particular occupation, then you can get rid of them that way. But we want to get rid of transferable skills to make the grid rules work. Okay. John Bray's greeting from, so essay like my joke about I'm guessing about the kids on the cell phone plan. John says, greetings from Galveston. Hello, John. I need some sleep. Yeah, I do, don't I? Like I said, I did work out with some weights pretty hard. And probably, you know what, the 3 slices of pizza I ate before I started this probably didn't help either, because it's probably, settling in my blood and thickening up. And so I'm putting me to sleep. So normally I don't really eat before I come on, but I had an early lunch today, and that pizza was just kind of calling my name. So I ate it, and that's probably also putting me to sleep a little as well, as was the cookie that I ate afterwards. So all my secrets now, but that's probably why I'm yawning too. Okay. Christina says, please don't forget to like the live stream. Yes. And it's 11:60 that is the trial work period, correct? Muley, if I was approved in initial and recon, they said my disabilities are more likely not to improve. How can an ALJ judge not approve your case if you appeal the onset date? That's a very, very good question. And what are the chances of that? So what he's asking is, the initial recon adjudicator found you disabled as of your 55th birthday, pick a date, and you go to a judge. The judge says, as they will all say, I'm not bound by any prior determinations, positive or negative, by the state agency. The judge could decide the state agency made a mistake. Now, I've never had it happen. I hope I never have it happen, but it could happen. Because realize judges are not bound by the denials of the administrative agency. Could they not be bound by the approvals either? They may feel like the state agency made a mistake. So that's, by law, an ALJ hearing is they call it de novo, which means new. Novo, I think it's Latin for new. It's a de novo hearing. So it's all brand new. So they're not bound by anything, but that's how. Muley says 7 years before probable CDR. Okay, so you're asking about in terms of a CDR that the adjudicator initial recon said, and I've seen those, that your disabilities are not likely to improve, and you're in a 7-year CDR. What are the chances? How can a judge, so if you got in front of a judge, because the judge is not bound by that. So the agency, this is administrative, it's not judicial. This is part of the executive branch. The ALJ can look at anything that an adjudicator did and said, you screwed up, you did it wrong. Now you can appeal that, but they're not bound by any of it. So that's how. That's not how. Okay. Let's see. Don P is 63, got approved after 2 years. Am I in jeopardy? No, you're not in jeopardy. I don't think. ACA is affordable. So I think what Alicia was asking is, what can she get under the Affordable Care Act? That's, again, it's sort of beyond what I do, but again, I'm happy to try to help any way I can. And like I said, we'll start maybe with talking to my buddy who does Medicare. There are a couple of people I know who have more Medicare expertise than me. Is there anything you can get while you're waiting for Medicare? Is the question. With advancements of Chat GPT and AI, where claimants are using higher level vocabulary and non-necessary court matters, this hurt future CDRs by appearing higher functioning, even though it's AI help. All right, so the question that This Is Life is asking is, when people use AI, that is, allows them to do higher level functions in theory, maybe beyond what they were educated to do. And in a CDR, is Social Security going to assume that you're going to have an AI assistant to help you do more stuff, is I think what you're really asking. I think it is way too early to tell. I will tell you that I'm using AI more and more. I use it to come up with ideas for videos. I will use it almost like I use Google, ask questions. When I'm working on a case and we got to, I use ones that are closed, so this stuff doesn't, go to the internet, obviously. It provides some value in summarizing medical records. Not 100% sold on that. I will also tell you that I've used AI to draft briefs, and I've seen, they call them hallucinations. For example, I did a blog post, and I was talking about consultative doctors, which we talked about a little bit earlier here. And the AI, I said, this is what I'm going to write a brief about, or a blog post about. Draft me up a blog post. It starts talking about the treating source rule. I'm looking and saying, wait a minute, treating source rule was eliminated like 7 years ago, but AI is talking about it like it. So I said, excuse me, Mr. AI, it doesn't exist anymore. Oh, yeah, you're right. You're right. It doesn't. So you got to be really, really careful. You can't assume anything is truly accurate. You got to do your own due diligence. You've probably heard of the cases where lawyers get themselves in real trouble because they are relying on AI, and the AI hallucinates case sites. And so it'll say Jones versus Smith, 335 F3rd, 263, 2021. And there's no such case. And the judge checks it and like, no such case. So I think we're a long way from now. It's happening quick. I mean, I'm in an AI mastermind group, and we meet every week, and every week there's something new. Chat GPT just came out with version 5, but we're not at the point now where certainly Social Security is not considering the effect of AI on jobs at this point. Ask me this in 5 years, maybe different, but right now it's not a factor at all for CDRs or anything else. Disability Life with Amy says, don't want anybody to give up on the benefits as a proof of SSDI when you're 50, now 58. Work file 1099 because I'm an independent contractor. So you are working part-time and still on disability. So as long as you keep track of the numbers, you're cool. Gun SSI subsidy form. I couldn't find anything on it. I didn't look that much, but I did, do a couple of Google searches. This is a question that came up a week or two ago about some SSI subsidy issues. I couldn't find anything in particular, so I'm sorry. I couldn't. I don't know where it would be, but I couldn't find anything. So I'm sorry. What is the time frame from application to DDS stage for your possible brief? Well, what happens is you file an application and the case is in limbo for a period of time. Now, I just had one in Texas that it was, why did that just, I think my webcam, which is now blinking yellow here, I don't know why it's blinking yellow, has this thing where if you move your hands, it will scan out or scan in. So I moved my hands, and it shouldn't do that, but it did it. So anyway, it's all blurred out there, but I thought I'd turn that off. Let me fix that real quick here, because I have the, got it there. Let's go back in a little bit so you get more me. There we go. Okay. Okay, back to the application details. So when you file originally, what ends up happening is the case kind of sits there, and then it is assigned to an adjudicator at the Disability Determination Services office. I just had a case out of Texas where my client had heard nothing. I called the adjudicator and I said, "We filed this case over a year ago. What's the story?" He goes, "I got it a month ago." That case sat there in limbo, before, nobody was assigned to it for a year. This is in Texas. And I got it. I said, "Well, my client is suffering. Would you please expedite this?" He promised he would. But there can be a gap of a couple of months to a year before the case is assigned to an adjudicator. So once I see by looking at the file that an adjudicator is assigned to it, that's when I would draft a letter or a summary or something. I don't want to call it a brief. It's not a full brief, but it's kind of a narrative of what's going on once I've got a person who's assigned to the file. And that may be a question actually that Spencer might be able to answer, Spencer Bishens, because I know he worked at various capacities in Social Security, or even Greg might be able to answer that, who's worked in different capacities, is, how valuable is it to have a summary or a brief written to the adjudicator. We've had a couple of adjudicators come here, and there's one woman who comments on my videos. Next time I see her comment, I'll ask her, does that make any difference to her? But I think it just helps me at least get the case summarized, and it may help the case with the adjudicator as well. All right, and this is that SSI form. It saved me from overpayment and allowed reinstatement of benefits, payment center letter process, critical pay required twice. So this is an SSI subsidy summary. If you can send me just ssdanswers123@gmail, send me some paperwork on that. Just maybe I can track down a form or something, because I couldn't find anything on it. When I looked up SSI subsidy, really nothing came back. So if you can send me something, I'll investigate it, because I'd like to know. But I just don't know exactly. I haven't found anything yet. Killer of Demons. Hey, Peter, my hearing's 2 weeks from today. I'm very nervous. All my records are up to date. Just writing up something for the judge this week, trying to prepare mentally. Updated my MRIs, my back, neck, knee, same results. Knee showing a slight tilt to the patella. Can see the judge. I'm struggling with pain. Can judge see that I'm struggling with pain? It's going to be in the record, Peter. I think what I would do is, for each of your body parts that are, problem, write down the specific problems that those that the problems cause, whether it's walking or standing or lifting, and then if you have objective evidence like an MRI or an X-ray that relates to it, know the exhibit page for that. But I think you just need to break down each part, but really focus on the specifics of how each of these injured body parts limits your capacity to work. Everything through the lens, I'll use my glasses as a model here, everything through the lens of how this affects you in a job, potential job. That's what you want to focus on. So everything's updated. So you're ready to go. Look up the judge as well to see what percentage judge approves. That could help you as well. Just got a post-hearing MRI that proves what DDSC report says was accurate. Submitted it. Okay, that's good. That will help. That will help. Raju Hoke. I'm 37-year-old with back pain, anxiety, depression, schizophrenia, back problems. Got denied because the judge says a medical record called it mild. The doctors are saying everything was okay. That is what they use to deny cases. They're saying it's all mild to moderate. And unless you've got evidence that it was more than mild to moderate, you're 37. That's what they're going to use to deny you. That's the problem. That is the problem. Your age, and more than anything else, I'm telling you, is your age. Very frustrating. I got rid of my pain management doctor because he was too lazy to send my records to my rep, then lied to my face about it. So I gave my bad review on Google. See a new doctor on Tuesday. There's no portal. You couldn't get the records from a portal. That's what we're using a lot of. But okay, hopefully the new doctor will help. Ray says, hello, Ray. Christina says, please like the video. It helps the algorithm. It does. Absolutely, Christina, it does. Let's see, update. Yeah, and again, I wouldn't pay a lot of heed to what the initial and recon adjudicator said. They're not going to really look for ways to approve you. They're going to, kind of minimize things. So you're not bound by any of that. You need to know what they said, but the judge is going to take a whole new look at it. Ray says, hello, Ray. Okay. If approved for SSDI, does Medicare wait begin from the date of onset or date of approval? Neither. It's from the date of first payment. So if you are approved with an onset date of, February 3rd, 2025, you don't get paid the first 5 months. You don't get paid the rest of February, March, April, May, June, July. Your first payment is August of 25, which means Medicare kicks in September of 27. That's the 2-year wait for Medicare. And if your first payment was 3 years ago, the retro payment was for 3 years ago, Medicare would kick in 2 years from the date of first payment there. It would be kicking in now. It would already be in. So look in the date of first payments is the date you need to focus on. You're welcome, Killer of Demons. Magdi Beckett. I'm 52, have a Zoom call next month. Should I appear with my back brace and neck brace, non-herniated disc? I would. It's going to be Microsoft Teams, not Zoom. But if that's what you normally wear, absolutely. Absolutely. Pardon me. Wow. This is a carbonated, it's like club soda, so that's why I did that. But yeah, I would definitely, if that's what you normally wear and you need it for support, you got a video call, let the judge see it. Sure. What's the best strategy? Asked Jeremy, when you meet several listings. Well, first of all, it's really hard to meet one listing, much less several. So that seems like maybe a little bit of an optimistic assumption, but maybe you do. I would focus on the listing that there's the most objective evidence for. So physical things like back, neck, heart, organs, things like that are probably going to be a stronger listing argument than depression, PTSD, anxiety. So I think I would focus on those things where you have the most objective evidence. Find the ones where you have the most support from your doctor. That's what I would focus on. Magdi says, I've got metal plates in my right or my leg. Don't have a diagnosis for that. Should I mention that or ignore it? I'd mention it. I think that this is your chance. Look, you've been waiting a long time for this hearing. This is your chance to get in front of a judge and tell that judge everything that's going on with you. So absolutely, I would tell you to talk to the judge about everything going on. Okay, Stephen, my client, things are moving on pretty good. I'll be 60. Is it my adjudicator requesting x-rays? And it's a grid rule I'll be qualified for. I have to look. I don't want to talk about your case just because of privacy issues, but yes, on the grid rules. And the adjudicator, I'm not sure exactly if you're talking about what specifics, in terms of a letter. I don't want to talk about letters and things we've gotten, but yes, this is a case that I think could be one where we get an early approval on. That's what I'm focusing on. I'll just leave it at that. We can discuss personal case, when we have a chance to, but yeah. MRI so and such. If you've got an MRI, that's helpful. That's probably a gold standard for many medical issues, MRIs and CTs. So if you've got an MRI that shows something significant, that's what I would focus on, probably more so than things like depression or anxiety, even if they're severe. Thank you for all the help. Have a great night. Be well. Thank you, Killer. Rob says, is MC Cardle? Ray, you got me on that. I don't know what you're asking there. Received an email that you had electronic access to my case. Only been 3 months. So waiting until, yeah. Okay. Yeah, we've got electronic, we have electronic access. That really opens it up. I'm looking right now at a utility or a file gathering thing that I look at. And so let's say I'm looking at, here's a client that got recently, I'm not going to show you obviously because it's private, but who we got electronic access to, and I'm seeing a lot of activity in this person's file. So once I see a couple hundred pages of medical records, then yeah, that might be one where I would be more inclined to want to start writing letters. Thank you very much, Stephen. I appreciate that very much. That was very nice of you. Thanks for tuning in. I'm glad to see you here. Let's just take a look since I've got you here. It looks like my Chronicle thing just went down, so I'm not going to be able to tell this better. Okay. Gojo, thank you for all the information. Good. Ray, is McCardle's eligible? Is that a condition? McCardle's disease is a rare metabolic disorder, a genetic condition where the body has trouble breaking down glycogen in muscle cells, leading to lack of energy during exercise. If it's severe enough, yes. I think it's just a matter of severity, because I think you could have this at different levels, but if it's at a severe level and you've got medical support for the idea that you physically are very, very limited because of this, then yeah, that could be definitely an argument for disability. What's the turnaround for OTR decisions? It depends on the judge. I mean, like I said, I got one for a hearing that was scheduled for today last week. It was pretty quick. Others, look, Spencer was on a couple of weeks ago, Spencer Bishens. He said that many judges don't even read the briefs. It just depends, if you can get the judge to read it or not. So I would tell you that in my experience, the last 7, 8, 10 on the record decisions I've gotten have been I've been notified of them within about a week prior to my hearing. So that gives you any sense. So no matter how early you submit it, I think the judges aren't going to look at it until much, much later. Okay, we are about done. So I get any more comments here. And okay, looks like that's about it. Okay, we're right up almost to 2 hours. So I appreciate everybody for joining me today. That was great. And okay, so that somebody talked about Medicare, which is again the 25 months after approval or after payment. So, all right. Next week I will be in a remote location. We're taking a little vacation, but I'll be here anyway. It'll be on my computer, so it won't be the same background. But I plan to do this anyway because I have a little time on Wednesday night. So I will look forward to seeing everybody next week. Maybe a little shorter, or may look a little different, maybe a little more sunburned. Who knows? But hopefully I'll be able to do this next week. I'm planning on it, assuming I have a good internet connection. And I'll look forward to seeing everybody next week. And then the week after, we've got a guest, another attorney who's a friend of mine who does a lot of teaching, has some really interesting videos about case preparation. We're going to talk about that a good bit. But next week, it'll just more likely just be me, and we'll go through our normal answering questions and talking about Social Security. So I look forward to seeing everybody back then. Again, if I can help you, please contact me through the link you see in the crawl, the Contact Jonathan 3. If you would, again, I mentioned my Instagram page, Ginsberg Law Offices, Ginsberg, Ginsberg Law Offices. Let me actually pull it up so you can see it, so you'll know you got the right place. you're at the right place here. And I've been doing some videos. It looks like I've got a couple people who've signed up, which is great because I'm trying to build that up as another platform. So that's what it looks like. So you'll see a picture of me and Jody, my wife. And then I've got, actually, this is an interesting video I did about what Ozzy Osbourne have qualified for a Social Security disability. Got a little fun with that. I did one on Hulk Hogan and on Ozzy. So if you want to know my thoughts about Ozzy or Hulk, click on the video and you'll see. But these are my, this is what it kind of looks like. So if you go to my Instagram page, please do so and subscribe. And I'd love to see you there. And I'll be doing, shorter form videos and some different things there. But I'm trying to build it up, just another channel than just YouTube. So I hope you guys check it out. And again, thanks everybody for joining me today. And we will see you next week. Take care. Bye-bye.